Welcome back to the Black Letter Law Academy. Today we are going to learn two important foundation article of fundamental rights, Article 12 and Article 13. If you watch this video until the very end without skipping, I guarantee you will understand the foundation so clearly you will never forget it. Let us begin with Article 12. First, remember one golden rule. Fundamental rights are mainly enforceable against the state. So, the obvious question is, who is state? First, the government and parliament of India, that is union level. Second, the government and legislature of each state, that is state level. Third, local authorities like municipalities and panchayats. Are local bodies like municipalities part of the state? Yes, they are expressly included. Now come the most important part. Article 12 also includes other authorities. Other authorities within Indian territory of India or under the control of the government of India. So this phrase other authority has been interpreted very widely by courts. So remember this clearly. Fundamental rights are enforceable not only against traditional government but also against certain other authorities created or controlled by the government. Now, how do you determine whether a body is state or not? The answer is given by court through what we call the test to determine whether a body is agency or instrumentality of the state. If a body is an instrumentality or agency of the government, then it considers state under Article 12. Okay. Now listen carefully. The court have laid down certain factors to determine state. Is the entity financially depend on government? If the government provides most of the capital, what does it indicate? Strong government involvement. Okay. Is the entity performing the public important? Does the government exercise deep and persuasive control over the body? Was it created to carry out the task that are traditionally government function? Now remember one important caution. Tests are not conclusive, but they are illustrative, non-exhaustive. Okay. This means no single factor is divisive. Courts look at overall picture. Let me explain this through an important case. In Ramana Dayaram Chetty versus the International Airport Authority of India, the question was whether the airport authority would be treated as state. The court looked beyond the labels. It noticed that government produced the capital, government controlled the key division, and the authority was performing public function. So the court said that this body may look separate, but in reality, it is an instrument of state. Therefore, it was treated as a state under Article 12. Later in Ajay Hasia versus Khalid Mujib, the Supreme Court went one step further. The body there was a society, not even a statutory authority. Still the court said if the government controls the body deeply, then the form does not matter. Even a society can be treated as state if it functions as an arm of the government. Here we say Article 12 is interpreted very broadly. Article 12 is not about form, it is about control and function. Now see, Article 13 is called the guardian of fundamental rights. Article 13 laid down one simple constitutional warning. The state cannot make law that violate fundamental rights. If it does, the constitution itself will step in and say this law will not serve. Does this apply only to new law? No. It applies to old law and new law. Okay. First, let us talk about the law that existed before the constitution came into force. That is pre-constitutional law. Many laws were made during British rule. Article 13 clearly says if any pre-constitutional law is inconsistent with fundamental right, it becomes void after 26th January 1950. Let me make this simple. Suppose there was a colonial law that is restricted free speech more than what Article 19 allows today. After the constitution came, that law cannot continue to operate against a citizen. So remember, old law serves only if they are compatible with fundamental rights. Post-constitutional law. Now what about law after the constitution? Article 13 is even stricter here. It as clearly says, state shall not make any law that take away or abridge fundamental right. If such law is made, it is void to the extent of violation. What does law mean in Article 13? Now students, do you think law means only act passed by the parliament? Article 13 gives a wide meaning to the word law. See, it includes ordinance, order, bylaw, rules, regulations, notifications, customs, usage, as long as they have the force of law. So, no authority can escape constitutional scrutiny by saying this is only a rule, not a law. Okay, Article 13 also explain what law in force means. It includes all laws made by competent authority before the constitution, even if they were not operational everywhere on that day. So, existence matter, not actual enforcement everywhere. Okay. Now come the most controversial part of Article 13. Can Parliament amend fundamental rights? This question led to the constitutional battle. See, in Shankari Prasad versus Union of India, the Supreme Court said constitutional amendments are not law. Okay, under Article 13, therefore Parliament can amend fundamental rights. This view was repeated in Sajan Singh versus State of Rajasthan. Then came a dramatic change in Golaknath versus State of Punjab. The court said amendments are also law. Parliament cannot amend the fundamental rights at all. Parliament responded immediately through 24th Amendment. It made two things clear. Okay, constitutional amendment under Article 368 are not law for Article 13, and Parliament has the power to amend fundamental rights. This restores Parliament's authority. Keshwananda Bharati versus State of Kerala. In this case, the Supreme Court held 24th Amendment is valid and Parliament can amend the fundamental rights, but it cannot destroy the basic structure of Constitution. This introduced the famous basic structure of doctrine. So this basic structure of doctrine means Parliament can amend the Constitution, but it cannot alter or destroy its core fundamental framework. This basic structure doctrine means Parliament can amend the Constitution, but it cannot alter or destroy its core fundamental framework or essential features. Okay. Now understand why Article 13 is so important. It is the foundation of judicial review. It gives the Supreme Court and High Court the power to examine law and stop them if they violate fundamental rights. Any law that is inconsistent with Part 3 of the Constitution is unconstitutional and void. So if any law inconsistent with fundamental rights is unconstitutional and void. Let me now explain a practical situation. Suppose one section of a law violates fundamental right. Should the entire law be struck down? Should the whole law be void? The Supreme Court answered this through the Doctrine of Severability. If the unconstitutional part can be separated from the rest of the law, then only the part is struck down and the remaining portion continues to operate. So that is, the rest of the statute remains valid. This principle is based directly on the words used in Article 13, which says that law is void only to the extent of inconsistency. So there is another important doctrine related to Article 13 known as Doctrine of Eclipse. This means mainly to pre-constitutional law. When such law violates fundamental right, it is not completely wiped out. It's not void ab initio, that is from the beginning. Instead, it becomes dormant. It remains on the statute book but cannot be enforced against citizen. Okay, cannot be enforced against citizen. However, it is still applied to past transaction and to person who do not enjoy the fundamental rights such such a non-citizen. If later the constitution is amended and the inconsistency is removed, the eclipsed law automatically becomes active again. That is why we say such a law is not died, it is only sleeping. The law is overshadowed by the fundamental rights. Okay. So when you understand Article 13 properly, you understand how the Constitution protects fundamental rights, control the power of the state, and maintain constitutional supremacy. Okay. So here is your sum up. We saw in part 3, Article 12, and test to determine the state. And then Article 13, Judicial Review, Doctrine of Severability, Doctrine of Eclipse. Thank you. Like and subscribe to the Black Letter Law Academy for more clear and exam-oriented explanation, and share it with your friends. Thank you. Happy learning.